Now we're going to talk to both plaintiffs and defendants, how to make the best of your day in court. Again, you only have about 15 minutes before the judge, so it's very important to make the best use of this time. First and foremost, you want to try gathering your documents. You want anything that's going to help the judge understand your case. This is called evidence. If you do have a document, you want to make a copy of it, one for the judge and one for the other side. And it's important to be organized. Again, the judge will ask you for something on the spur of the moment, and you want to make sure you have it on hand to give it to them. Witnesses are another form of evidence. In fact, what you tell the judge is evidence, and what third parties tell the judge is evidence, assuming that they have personal knowledge of the facts. If you have a witness, urge them to come to court with you. The judge will want to ask them questions and question them in person. If they can't attend, the next best thing is to have them write what's called a declaration, a signed statement under oath, where they tell the judge what they would say in court if they were present. If there is someone who you want to come to court, but they probably don't want to come, or you don't want to ask them to come, you can order them to come to court by filing what's called a small claims subpoena. You can also ask them to bring things to court with this form. Also, remember, you can have expert witnesses, but they are pretty costly. And you don't owe a witness any money unless they ask you for money. If they do ask you for money, you owe them at least $35 a day, plus 20 cents each mile they travel. But you can always get reimbursed for any witness fees that you pay as part of your court costs if you prevail. Now, small claims judges have a very active role. This is where I do want you to think about television. They will question you directly. They will question your witnesses directly. If you're a defendant, they will defend you with certain defenses, and they will ask you to submit certain evidence. There are two types of judges. One is called a pro tem judge, and the other is called a commissioner. They both have the same power to give you what you want. They're both attorneys. They're both very experienced. But the difference is that the commissioner is hired by the court. They are a court employee, whereas a pro tem judge is a volunteer attorney. If this bothers you at all, you have a right on the day of court to not give your consent for a pro tem judge and to ask for a commissioner. The only disadvantage is that you might not have your same day of court. And also, if you don't like your commissioner, you have a right before your hearing to request to have a different commissioner appointed. No questions will be asked. This is your right as a litigant. Now we're going to talk about some courtroom commandments, some important things for you to remember when you walk into that courtroom. First, you want to be respectful. Of course, you want to be respectful to the judge, but you even want to be respectful to the clerk who's taking notes and the bailiff who's maintaining order. These two people are often very close with the judge, like any employees in a workspace. If they don't have a good impression of you, they might report that to the judge in their chambers. How are you going to show your respect to the judge? You want to stand up, you want to dress formally, and you always want to say, Your Honor. Not Your Excellency, but Your Honor. You also want to be respectful to the other side, even if you hate their guts. Second, you want to be unemotional. A lot of these small claims are very emotional, but you want to act as though it's unemotional. What I mean is when the other side starts to speak and respond to your story, you don't want to yell out, Your Honor, he's lying. Instead, you want to maintain your composure because the judge will come back to you. And you can say simply, Your Honor, I don't agree with what defendant said about A and B because of C and D. Third, you want to be a good listener. Listen to what the judge is saying. Listen to what the other side is saying. They could be lying. You, however, want to be ethical and honest. You are taking an oath to tell the truth, and you want to take that obligation seriously. And many times the judge's decision comes down to a very simple question. Who do I believe? That could be because both of you submit to the judge a lot of good evidence, or because you don't submit anything, and all the judge has to rely on is your word. If you lie about one little fact, it could ruin the whole story. Finally, you want to be straight to the point. Oftentimes, the judge will ask you a very straightforward question that requires a yes, Your Honor, or no, Your Honor. And you think this is your one opportunity to speak, and you want to tell the judge everything. But remember that less is more, so respond with a yes or a no. Now we're going to talk about how to actually present your case in court. The best way to prepare for your day in court is to attend a small claims hearing before your own. You can sit, observe, these are open to the public. If you don't have time to do this, I will let you know what to expect. Please show up to the courtroom early and check for your line number outside of the courtroom. This will let you know the order of the hearings for that day, and you will find your line number next to your own name. When you step in the courtroom, the clerk or the bailiff will ask you to take an oath to tell the truth. And they'll also tell you to step outside to exchange documents with the other side, because whatever you want to show the judge, you first have to show the other side. And then they will let you know that this is your last opportunity to try mediation. And this is where you will try mediation if the other party agrees. If they don't, or if you reach an agreement, you'll still come back into the courtroom and wait to hear your line number. Once the judge reads your line number, you'll step forward with your witnesses and introduce them. And then the judge will turn to the plaintiff and say, "Plaintiff, tell me what your story is all about." The plaintiff should tell the judge in 1 or 2 sentences who they're suing, how much, and why. Then you want to proceed by telling the judge the rest of your story. You will tell the judge fact by fact in the order it occurred and try to present evidence to prove each fact. Do not wait for the judge to ask you for the evidence, because remember, you don't ask the judge questions, the judge asks you questions. So it's best to present that evidence and just offer it and then hand it to the bailiff. After you're done telling the judge your story, now you want to tell the judge why you did not contribute to the loss or how you tried to minimize the loss. This is especially important in cases involving car accidents or independent contractors or security deposits. Next, the judge will turn to the defendant and ask the defendant to respond to the plaintiff's story. As a plaintiff, you want to be listening to what the defendant's saying or what they're not saying. And try to write down what your counter-arguments will be, because the judge will come back to you to respond. Before you leave the courtroom, you want to tell the judge that you would like to have court costs awarded to you if you win. This includes filing fees, service of process fees, anything that you really pay out of pocket that's related to your day in court. If you forget, you can always ask for these in a form called a memorandum of costs and turn this in within 15 days of your judgment.